We're talking about the anatomy of a malpractice case, specifically one that goes to trial. Should a medical malpractice claim make it to trial? The first question is whether it'll be a trial by judge or by jury. Depending on the nature of the case, the attorneys can elect a bench trial, determined by judge alone, or a jury trial. And in a jury trial, the jurors are the triers of fact. In a legal proceeding, this means they decide whether the evidence indicates that something exists or an event actually occurred. The plaintiff always has the burden of proof. He or she has to convince a jury by a fair preponderance of the credible evidence that the defendant has not met the standard of care, and this is a failure that was a substantial factor in causing injury. In the case of a bench trial, where a judge is the trier of fact, the plaintiff needs to convince just one person. There are some factors that determine whether to try a case before a judge or a jury, and they can be related to the complexity of the case. A more complex case may lead attorneys to lean towards a trial by judge, but they'll first weigh whether or not they believe the judge has any biases. Conversely, if there are emotional factors at play, sometimes a jury trial will seem the most favorable. And this is because jury selection is about finding and keeping the people who are more likely predisposed to see things your way. Now, hopefully you won't ever find yourself in the courtroom, but if you do, here are some kind of need-to-know rules that your attorney would likely share with you. First, as previously mentioned, the plaintiff always has the burden of proof, whether it is to the judge in a bench trial or to a jury in a jury trial. 2, be mindful of a judge's instructions to the defendant during questioning, and typically the plaintiff will call the defendant for questioning first. They'll limit their questions in an attempt to control the evidence provided to yes/no questions, and your attorney will have the opportunity to cross-examine you, and you'll have the opportunity to tell your complete story on your attorney's cross-examination. So simply answer the plaintiff attorney's questions as they're asked. If needed, your attorney's going to object to any unreasonable line of questioning. Present yourself in an open and honest way. Be professional, likable, trustworthy, and thorough. Jurors understand this is a serious matter for all parties. The good news is people generally like healthcare providers. In a recent poll, 84% of respondents reported that nurses have the most honest and ethical standards of all professionals. That's good news. And finally, one of the most important rules is, as emotionally trying as it can be in court and attend the trial daily. So in addition to testimony, physical evidence will be reviewed. Mainly it's the medical record, but it's also phone records, tracking logs, or responses to labs and diagnostics, and additional witnesses, either from the hospital, clinic, family, or any appropriate setting, may be subpoenaed. Heads up about witnesses, it is especially important to keep your communication about the case just between you and your attorney. Anything you say outside of that relationship is discoverable. Once all the testimony has been heard, then both the plaintiff and the defense will present their closing arguments. The judge is going to outline specific instructions for the jury and advise them on any specific questions that need to be answered. Typically, the defense sums up first, followed by the plaintiff. The defense attorney will review the evidence, focusing on the provider's attention to the patient at every phase, and they'll compare experts. They'll claim that the credible evidence requires a verdict in the defendant's favor. There may be a verdict sheet and departure questions, read with arguments why each question should be answered in the defendant's favor. And the defendant is present. And after some time reviewing the facts, the judge or the jury is going to reach a decision. If the verdict is in favor of the defendant, the matter is settled. If, on the other hand, the verdict is in the favor of the plaintiff, the insurance company is notified of the amount to be awarded to the plaintiff, which, and all this assumes there's coverage, can be paid according to the policy's terms and limits. So there you have it, the anatomy of a malpractice case that made it to trial. We hope that this information is helpful to you and that you'll call us if we can be of help in any way.